Hello friends, welcome to Insights ICANN initiative. In today's video, we are going to discuss about controversy surrounding the Governor Office of the Punjab. So before we further discuss about this particular issue, now let us see the theme of the day. Today's theme of the day is State Executive Governor topic. When you are referring governor in Indian polity, you have to focus on these following areas such as source, from where we have borrowed, that means the office of governor, and some of the important articles related to governor, appointment, how the governor will be appointed and how the governor will be removed. Is there any special procedure for the removal of governor? Then powers and functions, especially discretionary powers of the governor. Now tell me students, who enjoys more discretionary powers, governor or president? Okay, put your answer in the comment section. Next, why role of governor is becoming very controversial these days, where the friction is happening between the governor and state. That these areas also you have to focus. Then important Supreme Court cases regarding the governor, important committees and recommendations related to the office of governor. What are the important committees and what kind of recommendations they given, like Sarkariya Commission, Punchi Commission. These are the areas you have to focus, especially when you are referring the topic that is governor. Now let us see some model questions on this particular theme. The first question, which of the following are the discretionary, here it is given clearly, discretionary powers given to the governor of a state? Sending a report to the President of India for the imposing the president rule. Okay, regarding the president rule, the first option is. Second, appointing the ministers. So you know students, appointing the minister is not the discretionary. If you remember, whenever chief minister suggests certain names, those have to be appointed. So this is not a discretionary. They are in the question they are asking discretionary power. Okay, that means option number 2 should not be in the answers. So 2, if you eliminate the second, so you can eliminate A, C, D. The answer must be 1 and 3 only. So that is how you have to derive to the answers by using the intelligent answering skills. That how to answer PYQs and how to use the smart techniques we will discuss definitely before the UPSC prelims. Now third option, reserving certain bills passed by the state legislature for consideration of the President of India. Of course, this is also discretion. Making the rules to conduct the business of the state government. No, they are not discretion. So governor has to follow the advice given by the Council of Ministers. So now in this question, answer must be 1 and 3. These are the discretionary powers of the governor. Now we will see one more question on this particular topic. Which one of the following statement is right? In India, same person cannot be appointed as governor for 2 or more states. Nothing like that. There can be a common governor for 2 or more states. Even the Andhra Pradesh and Telangana, they had common governor between 2014 to 2019. This statement is wrong. Okay, they are asking right statement. Judge of High Court of the state in India, they are appointed by the governor of the state. No. High Court judges are appointed by the president. Wrong. No procedure has been laid down in the Constitution of India for the removal of governor from his office. Obviously, Constitution was silent about the removal of governor. It is only saying about the appointment of the governor. There is no procedure similar to impeachment to governor. This statement is correct statement. In the case of UT having legislative setup, that means like Delhi, the chief minister is appointed by lieutenant governor, of course, on the basis of majority support. This statement is right. So which one is the wrong statement? C is the wrong statement. So answer is C. So these are the 2 MCQs. Now let us come to the main topic of the day. In today's video, we are going to discuss about Supreme Court comments on governor powers to decide on the bills. Okay, this is the main area. What happened exactly? Let me give one flow chart as notes, then we will come back to the notes. You know students, in Punjab Assembly, first let me explain. This issue is between the Punjab government and Punjab governor. Punjab Assembly, last year they had the winter session. You know, this winter session was never prorogued. It was only done, you know, like adjournment sine die was done. Adjournment sine die, it was done. Adjournment sine die means postponement without any further date. That means indefinite postponement. Adjournment sine die was done. Then again the house was summoned. In the form of special sitting. This was in the month of like June. special sitting, and they passed few bills. They passed few bills. Now these bills are pending with the governor. These bills are pending with governor. Here we will try to understand two sides of the argument. What governor argument is, okay? Governor arguing that this special sitting is unconstitutional in nature, because speaker cannot continue this particular session which started in the winter last year till the budget session. Speaker cannot continue one session perpetually. So governor argument is this particular session has to be ended in the winter itself, then the new session has to be called. Obviously when you are calling the new session in a particular year, governor will address. So that was not happened. The last year session is continued. This is against the constitution. The governor argument is special sitting of Punjab Assembly. Special sitting of Punjab Assembly is unconstitutional. Punjab Assembly is unconstitutional. This is what governor office argument. But government is responding that speaker has all the discretion whether to go for the proroguing of the session or whether to go for the adjournment sine die, that is the speaker office. Governor has no jurisdiction. So this is the argument. Now Supreme Court took a stand that as state government is right, and Supreme Court also observed that governor should not sit on the bills. Governor should not keep on pending bills forwarded by the assembly, because governor is only nominal head who is appointed by the president, whereas government is the elected one. In democracy, elected government carries more weight compared to the nominated governor, because elected government is responsible to the people but not the governor. And Supreme Court added one more comment as well. In this procedure of governors intentionally delaying bills, it is like fighting with fire. Governor system, they should not involve in this elected government functioning. And here we have to again refer some of the recommendations done by the Sarkaria Commission previously and previous Supreme Court observations in various judgments as well. We will discuss. I hope you understood the concept. And of course, Punjab government is also arguing that these bills which are pending in the governor office, they are very crucial bills in nature, and governor by not passing these bills, governor is obstructing the functioning of democratically elected government. That is the government stand. Let us see some of the important highlights of this particular issue. This issue is going to be helped to you in GS paper 2, Indian polity and constitution. Like I said earlier, now Supreme Court clearly mentioned that the real power of the elected government in the parliamentary form of democracy, it cannot be taken away, it cannot be stalled by executive. And Supreme Court also warned Punjab governor that you are playing with fire. That means you are you are interfering in the constitution machinery. That is right. That is wrong. That was the Supreme Court observation. Now, Punjab government complaining that these bills which are pending in governor office, they are very crucial in nature, such as they are related to Sikh Gurudwaras, related to police, and related to higher education as well. Like I said earlier, these bills were passed in special sitting of the budget session of the Punjab Assembly on 19th and 20th January. Governor is not ready to accept this particular sitting. Governor claiming that this is unconstitutional in nature because it is not the fresh session, it was continuing the last session, and presiding officer cannot continue one session perpetually. That was the governor argument. So Supreme Court supported whom? Supreme Court supported the Punjab government. Of course, Supreme Court also made one more observation that this kind of continuation for very long time of a particular session is not right. A session cannot be continued perpetually. That was also observation made by the Supreme Court. Supreme Court comments, real powers are vested with the elected representatives in parliamentary form of government. The governor is only appointed by the president. He acts as a titular head, that is only a nominated head. And governor is intended to be a constitutional statesman. That means he has to abide by the constitutional values in the matters of especially constitutional concern. And if governor don't know how to act, Wherever governor needs the discretionary powers, there governor has to take the advice of the Council of Ministers in the areas where constitution given discretion to him, as long as that government is having the confidence of the lower house. The power to take the decisions affecting the governance of the state. Okay, these kind of decisions governor should not take. These are essentially given to only elected government, not the governor. Let's see some information regarding the governor. Governors are generally appointed by the president office. Under Article 154 Clause 1, governor is the executive head of the state. All the executive actions are performed on the name of the governor, and governor will only act on the aid and advice of the Council of Ministers. In the Shamsher Singh versus State of Punjab in 1974, Supreme Court clearly mentioned that governor is the only constitutional head and executive power of the state is exercised by the Council of Ministers. Okay, that means real power given to the Council of Ministers, and governor enjoys only nominal powers. It is a typical parliamentary form of government that we have to understand. Now we will see B.R. Ambedkar. B.R. Ambedkar was mentioning that governor of the constitution has no function independently, no function, cannot be discharged himself, no function at all. That means B.R. Ambedkar expected that governor should not function independently. Governor always should take the confidence of the Council of Ministers. His action should be according to that. Even the Sarkaria Commission also mentioning that governor has to follow the aid and advice given by the Council of Ministers, as long as those Council of Ministers are having the confidence of the Assembly. Of course, if any decision given by the state government is, if it seems to be so unconstitutional, very grossly unconstitutional, then governor can use his discretion. When a particular bill forwarded to governor, what kind of options are there before the governor? Let me explain about this. Any particular bill, when a particular bill forwarded to governor, then the option number 1, the first option is, okay, governor may assent, governor may accept the bill. The second option before governor may reject the bill. And the third option before governor may return the bill. And if the same bill again with amendments or without amendment forwarded to governor, then governor has to accept. There is an obligation on the governor. And the fourth option can be exercised by the governor, that is governor reserving a particular bill to the president. This is the fourth option. When a particular bill reserved to president, obviously president also can exercise few options, such as president may give assent to the bill, or president may reject the bill, and president may not say anything. That means president can use pocket veto, and finally president may return the bill as well. President may return the bill for reconsideration to the state assembly. When president sends any bill to the reconsideration of the state assembly, here you have to understand state assembly has to respond within 6 months. Be careful when you are solving the MCQs. When president returns any bill to the state assembly has to act upon that bill and has to approve or has to return the bill within 6 months. That you have to understand. Okay. And here, according to Indian Constitution, there is clearly a verbatism, that is, when a particular bill forwarded to governor, governor shall act upon it. That means governor should do any of these following action. If governor is not taking any action, that means no action is not anticipated in the Constitution. Constitution never expected that governors no action on any particular bill. That you have to understand. That means eventually governor does not enjoy any pocket veto option regarding the state bills. That we have to understand. All this verbatism just now we discussed. When a bill reserved to president, what are the procedure? We discussed already. Even no action is not warranted under Constitution. Article 200 clearly saying that when a particular bill is presented to governor has to act upon it. Here they use the word shall. That means it is the obligation on the governor. What are the takeaway? Takeaway is giving assent to the bill passed by assembly is a part of legislative duty of the governor. Withholding that assent is alike extremely unpopular, and it neutralizes the value of the assembly, which is elected by the people's mandate. In UK, in country like UK, where the executive head such as monarch, they cannot reject any bill passed by the parliament. Okay, here we can quote those examples as well. What is the conclusion? The conclusion is governor or president, they are not personally responsible for their act, but at the end of the day, government, okay, government is responsible for their act. Government is accountable to the people. So this president or governor, they should facilitate, their action should facilitate the government transaction with the people. Rather than that, their action should not create any roadblock of the governance. Of course, certain reforms also been suggested by various committee. Here we can see BP, Justice BP Jeevan Reddy committee. It was saying that governor withholding a bill indefinitely, it will not a right to the decorum of a governor office, which expected according to constitution. And National Commission to review the working of the constitution. If you know, tell me students, who acted as the chairman of this particular commission. They also suggested that there must be a time limit to the governor office within which they should process the bill. There should be time limits. Those are the things we have to add. Now, let's see yesterday's video question. What is terminal high altitude area defense? Third, sometimes in news, it is related to American anti-missile system. We discussed this because yesterday we discussed about nuclear powered cruise missile developed by Russia. In that context, we framed this MCQ. Now we will see today's MCQ. Today's video MCQ. Under which article of the Indian Constitution the governor has the power to reserve a bill for the president assent? Under which article? Okay, pick the right one. Mains question. A governor should be discharging his duty in accordance with the spirit of the Constitution. Spirit of the Constitution, not just be an agent of the center. You know that governor will perform two things. One, he can act as an agent of the government and the second union government, and the second one is he is the head of the state. So governor should act like according to the spirit of the Constitution rather than a mere agent of the union government. Discuss the statement in the light of the role of governor in the Indian polity. So discuss this particular one regarding the role of governor in Indian polity. Now let's see. As we reach to the end of this video, in this video particularly we discussed about the controversy surrounding the Punjab governor, what is the controversy, and we also discussed about governor role in legislative process. In meanwhile, we discussed about Supreme Court arguments, Supreme Court judgments and various committees recommendations and Jeevan Reddy committee committee recommendations. These are the recommendations we discussed. And what are the options before the governor and before the president regarding the approval of state legislature also we discussed. So this is the detailed analysis of the recent controversy regarding the Punjab governor and Punjab government. Thank you.